So very warm welcome to everyone to this event organized by the School of International Arbitration, Queen Mary University of London. My name is Maxi Scherer. I'm a professor at the School of International Arbitration, where I hold the chair for international dispute resolution, arbitration, and energy law. I'm delighted to see so many familiar names in the list of attendees, both from our students, but also many external guests. I'm actually really pleased to see that all of you could attend. This is a seminar, a series of events that we have now run for a couple of years, but this is the first year we do this online for obvious reasons. And I'm really thrilled that rather than having less attendees, we seem to be having a much more than in normal years, which is a wonderful sign. It is also thanks to an excellent lineup of speakers, of course, whom I will introduce in a second. But let me maybe start by introducing the topic of our session today. COVID-19, of course, is on everyone's mind, probably far too much and for far too long already. And it has changed our lives in multiple ways, and that permanently. It is true for those who have, of course, tragically lost their loved ones or have been hit very hard, economically speaking. But even more broadly, the way we interact with each other, the way we do business has permanently changed quite significantly. Now, on a maybe more optimistic note, it also has had some positive side effects. For instance, on us as dispute resolution lawyers, we certainly have seen some positive changes in the way we practice. For instance, our knowledge and use of video conferencing tool for remote hearings is something that most people are now very well familiar with. Whether that is a good or bad thing is something that we are going to discuss during this seminar. It certainly has had positive side effects for our environment. That is for sure. So the many different ways how COVID-19, how the pandemic has affected the way we practice international arbitration is the topic of our seminar. And I am joined by an absolute stellar group of speakers whom you will all be familiar with, who do not need an introduction. We have Erica Stein, who's a partner at Dechert, based in Brussels, Belgium. We have Professor Mohamed Abdel Wahab, who's a founding partner at Zulficar and Partners in Cairo, Egypt. And we have Hafez Virjee, who is the co-founder and president of Delos Dispute Resolution. And I should say that we are most grateful to Delos for actually hosting today's event by the use of their video conferencing platform. Now, all three speakers, of course, have extensive experience in international arbitration as counsel. They sit as arbitrators. They have written extensively on the topic. I recommend you check out their CVs for inspiration. I don't want to spend our precious time in listing all the their accolades. We would certainly be sitting here still tomorrow. What you might not know, what I would like to mention, is all three of them are actually linked. Because they have participated in a recent book on COVID-19 and international arbitration, and that's probably also why they're here. It is a book that I had the pleasure to co-edit together with Mohamed and Nusha Basiri, and in which both Erica and Hafez have co-authored. Authored a chapter. So I do recommend you also checking out that publication. It's available online on Kluwer Arbitration, but we will be able to discuss, of course, some of their knowledge and thinking that has gone into their respective chapters today. Before I kick off the discussion on those topics, and I see more and more people are joining us. I wanted to just mention one housekeeping matter. We will have time at the end for questions and comments from the audience, but I would actually encourage you to bring on your questions and comments as we go along as well, so that we can feed them into the discussion as we go along. And you can do so by using the chat function, where you can put your questions and comments, or alternatively, maybe the Q&A function. I think they're probably both possible for you. We will keep an eye on both of them as we go along, so that we can pick up your questions and comments. Now, with that, and without further ado, I'm going to open the discussion, and I'm going to start off with some general questions. And maybe, Mohamed, the first one is to you. Can let us know what, in your view, how the pandemic, how COVID-19 has affected dispute resolution, broadly speaking.
Thank you very much, Maxi. It's a pleasure to join you. And I think, again, we are being moderated by the world-renowned Maxi Scherer. So it's a pleasure to be with all of you today. Let me say the following. Maxi has already said it all in response to that question, broadly speaking. But I will say the following. I think one important aspect that when we think about it in terms of dispute resolution, the pandemic has challenged the monotony that we have suffered in relation to dispute resolution. And I mean by that, despite the fact that we talk about dispute resolution broadly and international arbitration specifically as being very flexible processes in a way, over the years, they have spawned their own culture of practices that have acted in a way as difficult to move stones when it comes to practicing arbitration. Look at procedural orders, the order of submissions, hearings. When a party comes up with an idea about changing the order or moving a certain practice out of the way, it was looked at with a degree of either surprise or consideration. Why should we do that? Because things have been done and proven to have been successful in a certain way. So I think what happened with the pandemic is that has challenged this monotony or creeping rigidity that we have seen in practice. And that, I think, is a very positive development in terms of making people think about the practice, and has pushed the second element, pushed people out of their comfort zone. You now have to deal with technology on a daily basis, be it hearings or otherwise, dealing with less and less paper based filings and hard copies. And so people who are not prepared for this or did not prefer this are now pushed out of this comfort zone and have to deal with it. So I think that is another development. And the third one is that dispute resolution, and I think we need to remind ourselves of this ground rule, caters for business needs in a way. It's a service offered to businesses to resolve disputes. And if businesses have moved things online or are now dealing more and more with integrated aspects of technology, dispute resolution has to keep up with that. And specifically in the context of arbitration, the community has been able to successfully adapt, even more successful than national courts, for obvious reasons, in relation that it's more or less a private community. People can take decisions and adapt much faster. And so this, I think, has proven the resilience of both the arbitration community and the dispute resolution community at large, and the adaptability of practitioners, be it arbitrators, counsel, mediators, adjudicators, or whomever is involved in the dispute resolution process. And so it has given us, let me say, a window to think about the practices, come up with ideas, and challenge the rigidity that was creeping across the different processes.
So the idea also is the crisis as a positive catalyst for change. Erica, maybe, I don't know if you want to comment on that, and also, given your dual hat sitting as arbitrator, as counsel, how did you feel the change in your practice due to the pandemic?
Well, first of all, hi to everyone, and thanks also very much to Maxi for moderating us today. I love what Mohamed just said. I think it hits the nail on the head. I think that this concept of a creeping rigidity that was finding its way into international arbitration is true. And I do think that the pandemic, for lack of a better word, has shaken things up. I would say that there are two ways in which the pandemic has changed my work, my life, actually, both as an arbitrator and as counsel. They might seem banal, but in fact, it's pretty impactful for an international arbitration practitioner. The first thing is that I am not traveling anymore. And I was speaking with a friend in the field, and he said to me, I'm so frustrated I didn't become an international arbitration lawyer to sit in my home office. And while on the one hand that's true, on the other hand, and this is something that I think all of us had spoken about previously, with us being able to shift to traveling less, it has shown that we are adaptable. It has shown that we're able to continue doing our work. And I think it's also pushed us as individuals to open ourselves up more with the time that we have. I think that we're doing a lot more thought leadership. I think we're spending more time to think and to discuss the kinds of issues that Mohamed has just put forward. And I think so this question of the fact that we're just simply not traveling as much has given us space that perhaps we didn't have before for other ways for us to develop ourselves as international arbitration practitioners. The other way, which is perhaps less profound, is that the pandemic as a counsel and arbitrator impacted me with respect to scheduling. But I would say that this is in sort of two different periods. At the outset, there were extreme changes in schedules in terms of briefing schedules having been adjusted, and also schedules for hearings being pushed out. Now, as we're sort of later on in the pandemic, those extreme changes and changes in schedules are now actually just playing out. And I feel like in many respects, our practice is coming back to the day-to-day pace that we knew it from before.
Yeah, it is quite interesting that, in one way, all our practice has changed so tremendously because we don't travel anymore, we don't do the long haul flights, etc. On the other hand, I also feel that we were almost in the profession of lawyers, generally, probably those who are the best prepared for this, given that we've already been traveling so much, so been working remotely a lot of times because we've been traveling, and so having access to basically working where your computer is and your Wi-Fi has been a day-to-day practice for many of us. So Hafez, now turning to you, and I think what I would like you to maybe bring to this table is the institutional perspective and how you see from that perspective as a president of an institution, and maybe comparing to other institutions as well, how those institutions have been affected by the changes due to the pandemic.
Thank you, Maxi, and I'll echo the sentiment around the table. It's a pleasure to be here and to be moderated by you, so thank you very much. The institutional perspective is perhaps a little more granular than the perspectives that Erica and Mohamed have just shared. And to consider different layers, I think there was a similar effect at the start of the lockdowns where things might have slowed down slightly the time people adjusted, and then there was an acceleration. And the sense I have today is that around the world, there's been a bit of a build-up of a backlog in terms of catching up and adjusting through different work setups, as it were. More technically, and perhaps more interestingly, what was intriguing for me from perspective of Delos is when we wrote our rules, it was obvious to us that cases would be filed electronically. You send them to an email address, and I guess that's it's just the way we work as counsel. And there was that period of transition in, I'd say, March, April, May, where institutions were putting out messages saying, please don't file your cases with us in paper. We're not sure we can pick them up, or let us know if you're going to send couriers so that we can go and pick up the paper documents. And here's an email address, send it to us, we'll figure it out that way. And so I think that perhaps is the biggest impact that the pandemic had, at least at the start, on institutions. It was a sea change in how claims are started. And it's not just a practical consideration, that has also an impact on what's a commencement date for arbitrations. So that I think was pretty significant. Then if you take the narrative forward, I'd say maybe three trends I've noticed over the year are: one, an increasing tendency towards, or an increasing engagement with managing cases via online platforms. The SEC was quite a leader that way with its partnership with Thomson Reuters and making available its platform for free for ad hoc cases. You also had the platforms protocol that was released over the summer. And then generally speaking, there've been conversations amongst institutions about how do we go about it? What are the concerns? And as a result, a knock-on effect has been also more attention to issues like GDPR and cybersecurity. So that was one. Another is, and this Erica mentioned as well, thought leadership. But I'd say what's been interesting from an institutional perspective is the multiplication of voices on the one hand, but on the other hand as well, the ability to thread voices from contexts that don't usually come together. And that's my final point. I think from an institutional perspective, I think there was a responsibility on institutions to support the community as a community, to help the community come together, meet, and so on. And even if I'm saying though that with my institutional hat, I think by and large institutions have done reasonably well on that front.
I don't know if any of the other two, if you want to comment on that immediately, otherwise I'll continue asking some questions.
I think that, sorry, I fully agree with Hafez. I think one of the silver linings of the pandemic as well is the inclusiveness and diversity that has been brought. Previously, events, conferences, and institutions, people were sort of traveling acted as a barrier. We see the usual suspects. I think now it has opened up the door for people sitting in their homes, participating actively in the field of dispute resolution, which I'm inspired by Hafez's point about voices and threading in a way. So you've got fresh voices there, not just amongst the younger generation, but people who are normally alienated, example of which, those with special needs. Now, if you have a disability, it now does not stop you at all from participating and potentially from appointments or anything, because you can sit in the comfort of your own home and use your intellect to participate in cases. So I think this has opened a new window that I see that will have an impact on the profession at large.
Yeah, so the idea of leveling the playing field, it's a really hard one, because it also, sometimes I wonder whether, we have students participating here with us in the seminar. I sometimes wonder whether, on the one hand, it allows you to participate in more things, but on the other hand, it might also feel that you are lonely in doing so, because you're still sitting at home, and you cannot just randomly chat with someone at a coffee table at the conference. And I should use this as a reminder that you should encourage you to use this opportunity to ask questions, to make comments in the chat and Q&A functions. And I see that there are already a couple of comments to which I will get to in a moment. Let me ask you, Erica, the next question, because of course COVID-19 has also not only procedurally affected what we do as dispute resolution lawyers, but it has actually affected the substance. It has triggered disputes. And what I wanted to ask you, what you think are the key issues in those disputes that parties currently grapple with?
Well, during the pandemic, during the lockdown, a lot of people have written quite a bit about particular issues, such as questions of hardship, force majeure, change of circumstances, sort of as defenses against why performance wasn't possible under contract in COVID-related disputes. While I think that those are all obviously relevant issues and relevant to consider, I foresee that actually a much more basic and much more common legal issue is something that's going to become increasingly important and I think will be key going forward. In my view, in the cases, especially that are going to be filed going forward, where let's say a claimant has some sort of a loss that is crystallized from an issue in a contract that they've had with a counterparty, I think what's going to be the key issue is being able to actually prove that the counterparty is the cause of that loss. And that it's not the circumstances surrounding the economic slowdown that has been engendered by COVID and for other issues that would be external to the parties' relationship. So I think that this issue of causation will be a challenge for claimants who want to bring cases, but I think it'll also be a key issue for respondent parties who want to defend themselves from these kinds of cases. So I think that causation, which is, as we know from law school, is one of the most basic and fundamental building blocks of questions of liability and damages, is actually something that's going to come back and have real force, and we're not going to be able to sort of brush it under the carpet so easily anymore. It's obviously an issue that requires a lot of analysis, factual and legal analysis, factual causation, legal causation. And sometimes, at least I've seen in cases as arbitrator, those are questions that are not perhaps briefed as fulsomely as they otherwise could be because they're so complex to get through, especially from the counsel perspective. But I think going forward, it's going to be something that really, really is going to be key, especially in these COVID-related disputes.
And actually,
fascinating.
sorry,
Please.
if I may jump in here, I think not only will we see challenges as regards causation, but as regards quantification of damages as well. Because the same questions are going to come up in terms of saying, okay, you're claiming for X loss, but what tells me that that is actually your loss? What support maybe did you get from government schemes? Was your workforce actually available? So similar issues are going to come up also further down the line, and it's going to make cases that much more complex or interesting to argue. It's a matter of perspective, I guess.
I absolutely agree with you, Hafez. I think that's another very important point. During this COVID period, indeed, there's been a lot of state aid that has happened. Governments have come forward, given money in different sectors and for different kinds of businesses. And to the extent that claimant parties, for example, may have benefited from that, it definitely is something that is going to make the quantification analysis much more complicated. Should damages only be due for, a certain amount that's beyond the state aid? Should the state aid be taken into consideration at all? If so, why? If not, why not? Indeed, very complicated issues caused by the prevailing circumstances.
I actually just realized that there was one question that I had skipped in the Q&A that actually relates a little bit to what we've discussed before. So do indulge me and go back one step and read to you, I think, a very good question from Jessica, who says, with the change of having more electronic filings and the need to have entirely or nearly entirely electronic exchanges of submissions and documents, has this permanently changed the way documents will be handled during hearings? Additionally, have there been issues with confidentiality and concerns with data security? I think that's a little bit what Hafez mentioned earlier. So I don't know who would like to take a step on maybe looking forward, whether all these electronic changes with electronic filings are here to stay.
Sure, I'm happy to pipe in if nobody else wants to immediately. I do think that moving forward, electronic filings are going to be the norm. I have to say, though, that I'm not entirely sure that it was just simply the pandemic that brought that about. There had already been quite a push in international arbitration to go green. In most of my arbitrations as arbitrator and as counsel, The procedural orders foresee and have foreseen a green arbitration to really limit the amount of paper that gets filed. We had already started to go very electronic beforehand. And I guess that the fact that the pandemic, I guess, solidified what had already been, in my view, an increasing and growing practice is something that will make this endure going forward. And I think it's a positive development.
I fully agree with Erica, and let me say in very brief words, because I know Hafez may have an input as well. And I'd like to be robust there. The idea of hard copies of paper sort of filings will disappear completely. And I'm saying that because part of the Millennium Development Goals and the transition into a paperless society and digital economy means that, you know, people will be using paper less and less because of our environmental effect, but because of the nature of the evolutionary process of things. So what I think COVID-19 has had an impact on is catalyzing this in the context of our practice. And I fully agree with Erica. When sitting as an arbitrator or counsel, we always push as much as possible for paperless filings in a way, simply because in many cases it becomes impractical, in fact impossible, to walk around with bags of documents or receive hearing bundles of thousands of pages that are just put on the shelves that in fact no one touches because everyone is working from their own electronic devices, rarely. So I think there is much time, cost, and harm to the environment that is put there. And so the natural thing is that you will dispense with all this. And COVID-19 has shown us that it is doable. And so it's going to disappear. The paper hard copy thing, I think it will disappear.
So I definitely agree with the eulogy for paper filings. I think maybe there's a haiku to be written for core bundles, which may have a second life. But the one comment I'd make on the question is, one thing I've noticed, and I don't know to what extent any of you have seen it in your practices, but more attention being given to who's holding data and how that data may be seized. For this, by the very nature of the fact that, by the very fact that things are being now held electronically. So I've noticed a lot more attention to which servers are being used. If, for example, for a hearing, there's electronic presentation of evidence, where are the providers based? Which servers do they use? And relatedly, attention to, oh, but if I know of a case and I know of some of what's going on, maybe I can use some of that knowledge to gain access to documents in a way I couldn't previously. It's not clear to me yet to what extent that's just people speculating or whether it's actually happening.
I should add that this also relates to a couple of other points that have been made in the chat, that, you know, the pandemic has maybe helped making arbitration more environmentally friendly. If I may add, one of the things about electronic filings that I find quite important is to actually give directions to the parties how electronic numbering, for instance, is done, because it's a little bit like if you ask them to only give you electronic copies, but then, you know, the exhibit numbering is, you know, every party has a different one. It doesn't really help you. And I would just maybe point out that the ICSID, for instance, has a very strict numbering system when it comes to electronic filings, and that's precisely so that, you know, everyone is on the same page when it comes to numbering exhibits and how they are presented. So definitely something that going forward will also be of good help. I know there are a lot of questions about remote hearings using video conferencing. So I want to get to that topic. But before that, I have maybe one more general question to Erica. And this is the comparison between courts and an arbitral tribunal. Courts have you know, currently in the situation with COVID been quite backlogged, and arbitration, as we heard already, I think Mohamed mentioned it before has had an advantage in being more adaptable, being more, maybe also quicker in resolving disputes. What's your view on this? Is this going to stay in the long term?
I think that right now, arbitration certainly has an advantage over the court systems because, as you just mentioned, the court systems are backlogged. Arbitration is accessible if the parties so agree, and the procedures can be crafted to be quick and efficient. However, I have to say that my concern is because the advantage of arbitration is so obvious under the circumstances, that we as arbitration practitioners have been quick to say arbitration over court system, we're the obvious choice. I think that we need to be careful, and I think that we need to take a moment to reflect on ourselves and on our industry right now, because I don't think that it's just arbitration versus the courts. I think we need to realize that there are also other dispute resolution mechanisms out there that are even more efficient and even quicker than arbitration is. One thing that comes to mind is dispute boards. There are some ways and some thoughts out there that dispute boards can be used to resolve disputes outside of just the construction sector, which is where they traditionally were used. And dispute boards are less formal, even more flexible, even quicker. And so it might be that to the extent that COVID-related disputes, for example, need to be decided really, really quickly, parties might start looking to these other modes of dispute resolution that are even more efficient than we are. So if we want to be able to keep up, we can't sit on our laurels. We can't just say we're quicker than the courts and be happy. I think we need to make sure that we keep on moving forward to ensure that international arbitration remains efficient, remains fast. I know at the ICC, they're launching their new rules, and sort of expedited proceedings are being pushed forward with new force. I think that that's a good thing for us to be able to keep up as an industry. So to make a long story short, yes, under the current circumstances with the backlogs, arbitration is arguably a better place to be, but we can't take it for granted that we need to keep on evolving and improving ourselves as an industry as well.
Now, I'm mindful that there are a lot of questions in the chat and in the Q&A, and many of them relate to remote hearings using video conferencing. So I think I'm going to turn to that topic now, and then maybe if we have time, we can come back to some of the more COVID dispute in and of itself questions. So on remote hearings generally, I would like to shout out something that Hafez has done together with his two co-authors in the book I've just mentioned earlier, who are Annalise Day, QC, and Gary Bourne. And what they've done is really an extraordinary job in putting out, I think it was the first survey on the users of remote hearings, and Hafez can maybe share with us a little bit about the data they have received and analyzed on the feedback on how exactly tribunals responded in terms of remote hearings and the feedback from the users.
Thank you very much, Maxi. And the story wouldn't be complete if we didn't also acknowledge Maxi's encouragement to get this off the ground, because it was quite a large task, and we were fortunate to get a lot of support. In fact, thanks to that support, we had some 200 respondents to the survey, which meant that the results were very useful. Now, in terms of how tribunals responded, if we cast our minds back, March, April was a time when everybody was wondering, what do we do? And the biggest concern at the time was, particularly, what do we do with our hearings? Do those hearings get pushed back? Do we maintain them? By and large, as far as we could tell, since 15 March 2020, and as of the date of the survey, which was June, July 2020, about 40% of hearing dates had been maintained. And about another 40% dates were postponed, but the hearings were held. Or were scheduled to be held. Now, in order to do that with the lockdowns, we had a spike in remote hearings. On an annualized basis, we're talking about 11 times the number of hearings. And inevitably, that didn't go without some amount of concern and trepidation. So one of the questions we asked was, prior to your first remote hearing, what were your greatest concerns? And 2/3 pointed to technology issues, technology proficiency, internet stability. As it turns out, most people then came back, said, well, it turned out to be okay. Our remote hearings went well. But if you then ask participants, what do you consider generally to be the biggest challenges of remote hearings, you'll find that the biggest challenge that everybody flagged, and tribunals are not isolated in this, is technical issues. We were having a conversation earlier about digital fatigue. That was the second most flagged issue. I'll just add a couple more data points for the conversation before closing out. One is, we asked participants to tell us what their experience of remote hearings was. And what we found was that by and large, tribunals considered that fully remote hearings, meaning there is no dedicated hearing venue, so people are all connecting via their personal computers. A great majority, we're talking over 60%, considered fully remote hearings to be the same as in-person hearings when it came to putting questions to counsel as a tribunal. Even more striking, nearly 80% said that the fact of holding their hearings fully online did not impact their understanding of the case. Now, the one caveat to that is, actually, the first comment is, great, we adapted, we embraced, and we did well. But the flip side of the 80% is, you do have 20% saying that for them, it was a real issue to do a hearing fully online as opposed to in person. And so we can't just presume that everybody today is conversant with or comfortable with.
I'm sure Erica and Mohamed will have comments on, or maybe their vécu, how you have lived through this, and maybe sort of commenting on the data. And I should say, everyone, these is not only available online on Kluwer Arbitration as part of the book, but I think is also on the Delos website. So you can certainly find the survey and the data that Hafez just mentioned.
Well, absolutely. I can say the following. I think the experience so far with remote hearings, virtual hearings as people call them, I think it has been very good. I just look at this and say, perhaps in maybe 3 years' time, not more, we will look at this as a type of an obsolete practice, not the remote hearing, but the way we do it. Because I think we'll have new technologies that will render the existing type of technology or practice obsolete. I assume, and it's not inspired by just science fiction movies, but holographic visual projections, which we see now in airports, might well find their way into arbitration hearings. You may have, even now, people have portable lie detector devices, and how this would impact witness testimony. I think the practice is destined to change, not just because of COVID, but because of the accelerated pace that technology will take, and the integration of artificial intelligence by and large, since now technology has found its way globally into the practice of international arbitration. I think it's destined for an ongoing change, and it will challenge the very, what can I say, basic practices that we think will survive, and we think that technology will just simply be used as a tool. I think this all will change. And as far as the virtual hearings so far have been taking place, I think it is successful. And Hafez, Annalise, and Gary Bone's chapter in the book has been fascinating. This survey, I think, the latest survey as well that came out is the Stockholm Chamber. Actually now have their survey on virtual hearings as well. So I think many more will see that. But I think part of the thing we've been discussing before we started this, Maxi, is that some people have referred to online hearings fatigue or some sort of difficulty in keeping up for a number of hours, staring at screens and stuff. I can't say that I'm complaining about this, not at all, but I think it does take some time after you conclude the day of a hearing for the eye to adjust that you're no longer looking at a screen. You're doing it in solitude, of course, the dynamics of deliberations, the way you're looking at counsel, the cross-examination, the pleadings, things are different. But one thing that I have noticed is that people are more efficient with their time. I think this is a reality. Maybe not born out of a desire to be more efficient, but rather a fear that technology will fail you at some point in time. So at the end of the day, it has brought about a welcome development regarding efficiency. But I realize, and there's also a question that we've seen regarding whether remote hearings will survive COVID-19. I think they will. And I think that we will have hybrid forms. And I think ultimately we will have a situation where this will be a takeover from the traditional type of hearing. Now, of course, I realize that after COVID ends, more or less, hopefully soon, people will yearn and will want to have more and more physical interaction because of the lockdown or the restrictions that have been there. But on the longer run, I think it will be an option available there, and people will have to justify in terms of costs why a physical hearing is needed. So it does impact the burden of proof down the road as to what mode of hearing will take place.
I'm sure Erica has comments on that. Let me just remind everyone as well, while we talk about surveys, that the 2020 survey of the International School of Arbitration in partnership with White & Case, which this year is spearheaded by my colleague Nora Gallagher, who is actually on the line connected as a participant, so I shout out to her, is actually also on adapting arbitration to a changing world, and obviously that includes also the effects of the pandemic. So I would encourage everyone to have a look and participate in that survey, because you still have your say on that point. Erica.
I was just going to say that I think I'm still old school. Mohamed is clearly much more progressive than I am. I agree that remote hearings, well, there are different kinds of remote hearings. Procedural hearings, I think that doing them remotely has in fact been the norm for a long time. We were doing them by telephone conference for a long time. Now we're sort of switching over to Zoom and Teams and WebEx, and I think that that's an implanted practice. Then having hearings where you just have oral pleadings on the part of the attorneys, I think that that is another area where I'm ready to accept that it's an implanted practice going forward. I think that it has worked well, and there's a lot less room for trouble, if I can put it that way. However, for the full-fledged merits hearing that is remote, with many witnesses, many cross-examinations, the potential need for simultaneous interpretation of witnesses who are not speaking in the language of the arbitration, I think there is a lot of room still for things to get, well, literally and figuratively lost in translation. And since the purpose of a full merits hearing is to really clarify the facts, to the extent that remote hearings are, at least to my mind, and this is my opinion, not as effective, not saying that they're not effective, but not as fully effective as an in-person hearing for cross-examination of witnesses in particular, and even tribunal questioning of witnesses. I am not yet ready to say that full-fledged remote hearings on the merits are necessarily the way of the future. I think that there's still room for us to continue having in-person hearings to the extent that that is what the case requires. Obviously, there's a gray zone as to, or an area of appreciation as to what each case requires. But I'm not ready myself to fully embrace necessarily going forward full remote hearings. Now, I need to say that this may also be a question of time because of the fact that, as Mohamed mentioned, technology is advancing. And so perhaps some of the reservations I have remain technology related. It may also just be because for me, the remote hearing is new. It's pandemic related. And perhaps for practitioners who will, over the course of their career, more naturally have a full-fledged remote hearing, the reservations that I have will not be prevalent anymore in the field. So those are my few remarks about remote hearings.
I'm going to try to summarize a couple of questions because we have so many. And I'm going to put it to all of you. And this is, what are actually the keys to a successful remote hearing? And related to that, maybe how do you deal about, there are quite a few questions about how do you deal about trying to avoid any undue interference? So for instance, how do you make sure that a witness very practically in a remote hearing is not unduly influenced by counsel or any outside third party? And then we have a whole string of questions relating sort of to due process requirements, and we're gonna turn to that. But now for these practical tips on a successful remote hearing and how to avoid the problems. Mohamed, I don't know if you want to start on that one.
Sure. I think there is one word with 8 letters: protocol. I think now hearing protocols for an online hearing is a must. Is a must in a number of ways, not just in terms of the logistics for the hearing, to cater for all these issues that have arisen in practice. And I think it is an enjoyable experience because it's a build-up. Every hearing raises a number of issues that you update your protocol accordingly. Be it witnesses, no virtual backgrounds because you want to see the room, different approaches. Should the witness or the expert be logging in with one camera only or another camera from the back and the side and the front, looking at the table, looking at a 360 degrees view of the room, where the location or connection is going to happen from. Are we using interpretation simultaneous or consecutive or sequential interpretation? How and for how long the cross-examination is going to take place. And I agree, by the way, with Erica, is that the dynamics of cross-examination, for example, has changed. The witness is not within the physical grab of the cross-examiner. They're not in the same room. The witness might be well in the comfort of their own home with which they're familiar. So not necessarily under the same level of pressure that you might see in a room. Though other witnesses, and we've seen that in hearings, may find it awkward and pressure to an extent, concerned about something going wrong in the technology and then being accused that they have taken something not to answer the question. I think it is extremely important that you have these protocols in place, and they're becoming very dense in terms of the information contained therein, step by step, logistical, technological, procedural in terms of the hearings. And I think this is a work in progress area where we're just every single hearing, there is an added value of something that you normally encounter and something that is quite peculiar to what you have seen before. And I think the competition is also high between providers, because now you see people offering gold standards in the current state of virtual hearings, others, some issues. It's a trial and error thing about the platforms they team up with to offer the virtual hearing services, the database for documentation and the platform offered. So I think it's a fascinating area, and I think it's something that is inspired by the practice of remote hearings themselves.
I would just add, I completely agree with what Mohamed said. Protocols are critical, and there are increasing number of protocols that have been coming to the fore during the pandemic. Some of them sort of a public template nature so that everybody can benefit from it. And then obviously each arbitrator, each practitioner is also developing protocols in the context of their cases. So I think we are converging on a set of best practices. The other thing that I wanted to add, and this is something that's frustrated me in some ways from the beginning of the pandemic and the question of witness tampering. I think, well, I should say, my frustration stems from the fact that I think we cannot forget that the fact that hearings are remote is not divorced from the fact that lawyers have ethical obligations. We are bound by the ethics of our local bars. And as international arbitration practitioners, they're also, for example, the IBA guidelines on party representation also have various, I would say, benchmark rules with respect to ethical obligations. And so I think that we shouldn't focus or create too much about issues of witness tampering on the part of lawyers because of the fact that we have ethical obligations. And I think our point of departure should be that everybody is following those obligations. And then we can't forget that also witnesses are asked to tell the truth by the tribunal, be it an affirmation, be it under oath. And to the extent that a witness is going to lie to the tribunal, which would be unfortunate, I do not think that the fact that they're doing so in a remote context changes the fact that they would have lied anyway. So in that sense, I think that this question of witness tampering also needs to be looked at with those two touch points in mind.
There's very little to add on my part. I think the only, so obviously I completely agree with both Erica and Mohamed, and the only additional contribution I'll make is the shape of hearings may also be changing in that what we once saw as one block it now may start to be deconstructed with, for example, a two-hour scheduled on one day to hear one witness, and then separately another 2 hours to hear an expert. So the practical side of how hearings are scheduled may also evolve.
I think that's a really important point, and that I think goes back to what Mohamed said at the beginning, sort of the rigidity we had, that it had to be 1 week, all in one go, because we were together in one place, goes away once we do things online. And that actually means that potentially, we can have a break between the evidence taking and the closing submissions so that people can actually digest, both counsel and the tribunal, what we've just heard before we go into the closing submissions. And it's certainly something that I've seen in some of the cases in the past weeks and months with done, quite effectively. So I think that's a very good point, Hafez. Now, again, I'm trying to summarize and get together a couple of questions on the chat. Keep coming. They're wonderful questions, and a lot of them. So quite a few of the questions relate to questions of due process. I should say this is the chapter that Erica has written in our book. Oh, and by the way, little footnote, we talked about protocols. Nusha Basiri has a specific chapter on protocols in the book, so I also recommend you read that. Now, due process rights. The question is, what do you do if one of the parties objects to a remote hearing? Can you sort of impose a remote hearing in these circumstances? And if you do so, is there a risk that the tribunal or the ward is going to be challenged? And maybe related to that, there are also other questions that have said, under what circumstances would you say it would be correct not to go with a remote hearing? What are the specific circumstances that you would take into account in order to say this really should be held in person? So maybe Erica, if you would like to start.
Sure, with pleasure. So this due process question, I think we need to look at it at two different moments in time or two different levels. One moment in time is when the tribunal takes the decision to order a virtual hearing. And the other moment in time is in the context of enforcement proceedings, of the award. At that first moment in time, when the tribunal is deciding whether or not to hold a virtual hearing over the objections of one of the parties, the short answer, in my view, is that as long as the tribunal has heard both sides' positions about why they do or do not want a hearing, and they take a decision accordingly, without violating the ability of the parties to express themselves at that moment, the decision to order a virtual hearing, I think, will not be impugned by any court. This is not a due process violation to order the hearing. It's generally accepted in arbitration and by national courts around the world that arbitrators have the right or ability to run the proceedings as they see fit, as long as they are treating the parties equally, giving them the opportunity to be heard, etc. So for this procedural decision to order a virtual hearing over the objections of one side, as long as that decision is taken, having heard the parties on that issue, I think that that is a decision that will not be problematic. However, before I proceed to the award enforcement part, I'll just pause for a moment to answer that question about, well, but when could it possibly be problematic? Because that's a general rule, but what would be the exception to that rule? Frankly, to my mind, I think that the most flagrant moments where the tribunal should give pause as to whether they should move forward with the hearing are: one, if one of the parties really has extraordinarily problematic or no proper access to technology, be it because they're in a country where there's an general infrastructure problem, because perhaps they're not represented by by a firm that has the access to all of these platforms. There needs to be an examination of that, and if there's sort of an egregious lack of access to technology and infrastructure, the tribunal should not order a virtual hearing. The other time, and I think that this would be extraordinarily rare and perhaps difficult to know, but would be if, for example, there would be a real risk of a government listening in on a hearing because of censorship or other sorts of local laws that one of the parties attending the remote hearing would be subject to. And if that interference would cause problems either directly to the party or to the integrity of the arbitration itself, I think that that would be another circumstance where ordering a remote hearing would be a problem. But aside from those two fairly extreme examples, it's hard for me to think of examples where the tribunal should really just from the outset say no. Then the last part of my explanation is regarding the enforcement of the award. I think you can understand from what I've just said that the tribunal's decision to hold a remote hearing will not be problematic for the enforcement of award for the reasons I mentioned. A different issue is if something egregious happens during the hearing itself. So if during the hearing, the technology completely blacks out and yet the tribunal, for one party, and yet the tribunal decides to carry on with the hearing, this would be a problem. If during the hearing, one of the parties prevailed upon the tribunal to mute the other side during the entire hearing, this would be a problem. So, but these are not things that are sort of foreseeable in advance at the moment of taking the decision. These are things that would arise over the course of the hearing itself, and who knows what it would be. It's like looking into a crystal ball. So I'll leave my comments there.
Mohamed, Hafez, anything you would like to add, maybe while you're structuring your thoughts, I can point you towards one particular decision that was rendered not so long ago by the Austrian Supreme Court. And as far as I know, it's the first decision of a Supreme Court that deals with remote hearings in international arbitration. There were other decisions by lower courts. There were other decisions by Supreme Courts, but that dealt not with remote hearings in arbitration specifically. But this is a first, as far as I know. It has very clearly said that remote hearings in and of itself, just as Erica said, even over the objection of one party, cannot be a cause for challenge. In this case, it was actually a challenge to the tribunal, not to the award. In and of itself, that does not mean that maybe in one particular case, because something has happened during the hearing, it might not be a cause for a challenge. But the mere fact to say we are going to proceed remotely is not. And actually, quite positively, the Supreme Court has said no, even in the pandemic, it's not hindering the right to be heard. It's actually enforcing the rights, the parties' rights to be heard, because that's how we give the parties an opportunity to proceed with their case. Otherwise, everything would be backlogged and we would still be sitting here in 2 years and not being able to resolve the parties' dispute. So it is actually a means of giving the parties a right to be heard as opposed to violating it. So I'll stop and I'll let Hafez and Mohamed comment.
Let me first congratulate you, Maxi, Erica, and Hafez so far. And I'm going to say that so that we keep up this. This is the first webinar, and we've all participated a lot, where we have not fell into the common mistake of speaking while on mute. Every single time we've been speaking, we manage, which shows, again, adaptability, learning much faster, because it happens in any webinar that there is someone who's going to speak when they are on mute. So far, our record is 100%. So hopefully we continue like this. Let me say the following. I mean, it's an excellent question, and Erica has provided very insightful views, and you complimented that. I was going to mention the Austrian Supreme Court, and it is, as you mentioned, the crown jewel so far of these decisions. Very recently as well, we've had on the 27th of October a decision by the Egyptian Supreme Court, the Court of Cassation. It is not related to remote hearings at all. But in the context of the decision, they included a 2-liner statement that online hearings are on the rise and increasingly being used in international arbitration. So all practitioners are trying to make so much out of it in terms of the courts endorsing this. But let's look at the reality. Courts themselves are moving their hearings online. So it is very interesting. It would be very interesting to see if one were to challenge the mode of the hearing or challenge an award simply on the mode of the hearing, how courts would receive that. As Eric has mentioned, and as you mentioned, the mode of the hearing per se may not in and of itself qualify as problematic, subject to the parameters that the applicable law, the applicable rules do provide for this, which I think in many jurisdictions, examples, the UAE arbitration law, the Jordanian arbitration law provide for express reference to video conferencing and hearings on the merits for that purpose. Other laws may be silent, but institutional rules have offered either rules or guidelines that support proceeding online. Eric has pretty much covered the scenarios where you would not order an online hearing. I think one additional possible scenario is that where the case wholly hinges upon witness testimony and the witness has no access to technology, not just the parties, or the witness is somehow impaired in terms of technology to the extent you don't have a reliable connection, and it hinges completely on that type of testimony. So, which is a very extreme scenario, then I think the only option would be to proceed physically. But I'm reminded of the point that with all these scenarios, it means that in the future, people will present the virtual hearing option as the viable, cost-effective, and more efficient option. arbitrators and parties do not need to travel. You actually circumvent visa requirements, which we know to some nationalities and people is a problem. So it is indeed very interesting to see how the situation unfolds. Now, not surprisingly so, it is very common now in arbitrations that one party will object. And increasingly so now they object in terms of reserving their position without making much of a fuss about it. I think what COVID has shown people is that it is not that virtual hearings are related or remote hearings are related to COVID-19, but it's more of a fact that it has accelerated this transition into a paperless environment in a way. And we tend to forget one important thing, that in many laws, I'm not saying all, but in many laws, hearings themselves are not a requirement. They're not mandatory. So if you can proceed with the documents only, then surely the mode of the hearing would not matter that much. And perhaps for our participants, ECA has started a task force on or not, and that is a task force that has started, and they have already started in terms of looking at different jurisdictions. So perhaps a study to that effect would be interesting. I think Hafez can add more to that, but it's definitely an area for further development.
Given the excellent comments from Erica and Mohamed, there's really very little to add, only perhaps to note that I had the pleasure of editing a publication known as The Gap under the chairmanship of Maxi. And one of the things we're looking to do for the second edition is a systematic review across all of the jurisdictions covered in the guide about to what extent it may raise an issue to hold an issue remotely if your arbitration is seated there. So by, let's say, second quarter next year, we should have a fairly exhaustive view of due process concerns, if any, across a large swath of the globe.
Now I'm going to put you on the spot, everyone. I'll give you a heads up with two very, I think, tricky questions from the chat. One is related to the question under which specific circumstances one might find that an in-person hearing is necessary. And one could be, and this is what the question is about, if the arbitration clause actually provides that the hearing should take place in a specific location. So not just the seat of arbitration, but the venue actually should be in a particular town. Is that, in your view, enough for the arbitral tribunal to say we cannot proceed remotely? Tricky.
It is a tricky question, and let me chime in by saying the following. We're talking about the location, but it doesn't necessarily say. It is, by the way, the same thing when people include in-person hearings. And I don't know who suggests that in-person does not mean that we're not appearing virtually or remotely or online. We are the same people. Still, it is in person. It is not physical, but it is in person. I think the answer to that is that in location does not mean or does not require people to be directly in that location. Could be the location of the servers, the people, someone logging in from that location. But if people were to include in their clauses, it should be physically held X, then I think there's no way out, and it has to be held actually physically. I think the tricky part is that if someone develops that argument further by saying, well, even if the location mentioned may not suffice in and of itself, it does show that the scenario contemplated in the parties' minds before COVID-19 was that it must be physically in person, and the common intent as a presumption is shown by choosing a location. And here I think the common intent element is an issue that tribunals have been grappling with to see whether you can import something as a new development that was not only not in contemplation of the parties, but there is a presumption to suggest that the contemplation was to proceed physically. I think it gets trickier to that. So far, tribunals, because of practical reasons of proceeding, and there is no visibility on to when a physical hearing could be scheduled have found different arguments for a way out to proceed. So it has not stopped tribunals when the parties have included a reference to a location or a venue by saying perhaps one person or whatever can start the connection from there. And I don't think that courts have taken a rigid stance in this respect.
I agree with Mohamed that in the event well, first we'll start with the lawyerly answer. It depends on what the clause says in toto. So we would have to see what the whole clause says, and then we would be able to come up with an interpretation. In all events, I agree with what Mohamed said, that if an arbitration clause expressly says that the hearing shall take place with all participants physically present, that's pretty difficult to derogate from, unless the parties subsequently agree otherwise, which wasn't the constellation we were talking about. But if that is not what the clause actually says, and it just says the place of arbitration shall be New York, and the state of New York, and the venue shall be, the place of arbitration shall be New York City, and the venue shall be, I don't know, the Marriott Hotel in Manhattan or something like this, you could read that as saying that this is the venue in the event that the hearing takes place in person. Not to the exclusion of in the event that hearing might take place remotely. That's another way of looking at it. But it's an excellent question. Let's see what winds up happening. Maybe this will wind up going through the courts more than it has. And I'd be interested to see what actually comes out of it. And I'd be interested to look at some clauses that have that language, because indeed, I think the specific terms chosen will be very important to actually be able to argue that one way or another.
It's difficult to add anything to an answer, which I also agree with, is fundamentally it depends, and it depends on the exact language. But maybe just to take a slight tangent, pre-pandemic, I tended to think of clauses that said the seat will be versus the location will be as a good way to promote certain jurisdictions that may not see as much arbitration go through them. And I'm wondering, as a result, what the impact of these sort of discussions will have on those efforts to promote certain jurisdictions.
That's a great segue into my next tricky question, which is not mine, but from the chat. And it's a combination of two questions, one from Ahmed Afifi and one from an anonymous attendee. And they both ask the consequences of online hearings, how, on the one hand, they might negatively impact poor, underdeveloped countries on the short run, as they might not be as well prepared technically. And the other one asking how it might impact or give an edge to bigger firms over small-sized firms, again, because there may be the technological arsenal and the understanding of this new medium might not be as good. Hafez, maybe I'm going to put you on the spot now, if you want to start with these, this combined question from the audience.
Well, actually, I'll add a third question, which is to go back to what Erica and I were saying about causation and damages. What does all this mean for smaller cases? Because smaller cases or smaller value cases, because they're not necessarily less complex, but you're typically going to also allocate fewer means to resolving those. Unfortunately, there is no silver bullet on any of these questions. And for want of a more satisfactory answer, I would say it's going to be a case-by-case situation. I would tend to think that even if the preference and the trend for bigger value cases will be, when possible, to go back to physical hearings, that the move or the adaptation to an online environment is actually beneficial to countries where that are, to quote the question, that are poor and underdeveloped. Because even if they have fewer facilities, it is still possible with enough organization to organize oneself. It may take more time, it may take more means. It's still less, I would imagine, than to take a whole group of people across continents for a long period of time. The level of logistics and implications are just not the same.
I would add, I guess, to what Hafez said, and in response to those very important questions. One thing is, I would go back to my comments earlier about due process. If at the time that the tribunal is deciding whether or not to order an online hearing, there are obvious impediments to one or the other party having proper access to technology or things like this, I think that then in that event, that would be a circumstance where the virtual hearing should not even be ordered in the first place. However, barring a very extreme case where that might happen, what tribunals have been doing in order to address the fact that there can be disparities between access to technology, mastery of technology, depending on geographical location or the kinds of firms involved in the case, tribunals have been putting in place test runs of the technology that's going to be used, so that one day, several days, if necessary, in advance of the hearing actually taking place, the parties convene on the virtual platform. The platform is navigated by the parties, by the tribunal, in order to ensure that when the actual hearing takes place, everyone is at least as familiar as possible under the circumstances, so that some of those disparities will be minimized.
Can I chime in again and add a few thoughts to the excellent comments Hafez and Erica have stated? Let me say the following with a broad reservation. To the extent that the human element in prosecuting a case plays significant role, and technology serves as a communication or a supportive tool, I think it's fine. To me, it's more like the language. Imagine one counsel masters the language and the other counsel doesn't really. You will probably have similar issues, and it hasn't impacted much. But if technology is going to take over and artificial intelligence plays a significant role, then it might impact the outcome in a way, or the way the proceedings are prosecuted, because you will then have different versions and different layers of technology. But I think what we tend to overlook as well, we think that the use of technology is also a function of developed or developing or underdeveloped countries. But let us take practical examples. For example, in Sri Lanka and the Philippines and other countries, the access to technology and resorting to mobile phones, for example, has been much higher than in developed countries, because of the infrastructure there makes it difficult to have fixed lines. So developing and underdeveloped countries have found that technology offers better opportunities for them in terms of doing business, in terms of conducting their affairs, communicating. So they're not alien to technology. I think the challenge, though, is not in the existence and accessibility to technology, but on the existence of safe and secure servers in certain regions and parts of the world. And this is the challenge, because, for example, on the African continent, we can't speak much about the availability of secure servers compared to other places, or the best type of technology being available, though this is increasing at a momentous speed. And governments are definitely investing a lot in the IT infrastructure. And I think gradually the gap will be more or less closed, or let's say reduced. What I'm more concerned about is the artificial intelligence applications.
And actually, if I may follow on from that, to go back to the question about bigger firms versus smaller firms, if we, and I agree with Mohamed, artificial intelligence may be a game changer. But if we put that aside for one moment, I would tend to think actually that the current environment is a positive for smaller practices at two levels. One, it's easier to coordinate fewer people than a large team. And second, the way services are procured, they tend to have a geographic anchoring to them. Whereas the way our market functions, you or I could be anywhere in the world and it really wouldn't matter. But where there is an impact is in the rates we can charge. And at that point, being a smaller firm in certain jurisdictions may mean you have lower rates, lower overheads, just the same quality. And so it's not an obvious proposition to me that bigger firms would necessarily have an edge. I think what all this means is that you'll have more segmentation in the market in terms of which clients go with which firms, as it were, or which disputes go to which firms.
Now, I should say that there are quite a few questions on the chat that actually relate to AI, artificial intelligence, and influencing on our decision making. This would probably be a good topic for a whole new seminar, so I'm not going there, but excellent questions anyhow. I am mindful of time, that we just have a couple minutes left, and I wanted to go to one further topic. So leaving behind now remote hearings, which is of course an important part of our practice in COVID-19 and beyond. But I also wanted to touch base on e-signatures of awards. Personally, I think that has been one of the most frustrating experiences beyond during the pandemic, and that is to try to get awards signed by co-arbitrators who have disappeared in faraway country houses, or myself to sign awards, to get a courier service delivered to my house and get it picked up again. So of course, this is quite an old-fashioned way of actually having to sign awards with a wet ink signature. And you will know that some institutions, the LTA, for instance, in their last 2020 rules, have included the possibility for e-signatures of awards. I'm not going to read out the provision to you. Most of you will be familiar with the new Article 26.2. But maybe, and Erica, if I may start with you, whether you think it's an effective tool during the pandemic, but also maybe beyond, these sort of e-signatures of awards.
I hate to disappoint you, Maxi, because even though it may make arbitrators' lives easier, I'm not sure that it is I'm not sure that they're actually helpful in the long term. First of all, e-signatures, you have to look at the place of arbitration. If there's a mandatory rule at the place of arbitration that says that an award cannot be signed electronically, that's pretty much going to be the end of the story there. But let's assume that the law at the place of arbitration either allows it or doesn't say anything. Then fine, we can, proceed on that basis. But there are a couple of issues. One issue is that when an award goes before national courts for enforcement, many national courts require an original of the award, or they required a certified copy of the original of an award. So I think that the parties would need to agree that the electronically signed award constitutes the original in order to be able to give that award the greatest chances of ticking all of the administrative boxes before the enforcing courts. And even if the parties agree that an electronically signed an award can constitute the original, frankly, who really knows if the enforcing court will accept it as such? So I think that it's a great initiative. I think that it was a stopgap measure during the pandemic. I think it can be helpful for actually being able to notify the awards to the parties in the first place, because some institutions previously wouldn't even really notify an electronic award at all, at least back in the day. But at least now these awards can actually get out to the parties. But as for the legal effect of that electronic signature, there are a lot of things that are in the mix that can put it at risk. So those are my few comments on on e-signatures.
If I may, in 1 minute, Eric has set out the scene in an excellent, well-structured way. And I fully agree with what she mentioned. And I was going to add, assuming the parties agree, there are many jurisdictions that will not consider this to be an authentic or an original document. The very same is in some parts in Africa and the MENA region, even with countries that have e-signature laws, by the way. But the one thing that I want people to consider is that there is a distinction between e-signatures and digital signatures. The signatures we have in the emails or we put as an image is not what people are talking about when it comes to authentic or original forms of award. The awards that I've seen coming from the US, sitting with people, it is using more or less PKI infrastructure or sort of certified type of thing, encrypted in a way. And to that extent, I think in many parts of the world, courts have yet to catch up or are yet to catch up with this practice. So far, out of abundance of caution, people are signing with a wet signature. And in some instances, they avoid even signing with a black. They want to sign with a blue or a red to show that this is not a copy. And we are now even today living in an era where we have certain decisions out there. There is a recent decision that came out from the UAE courts in June, where they thought that arbitrators should sign every page of the award, not just the final dispositive. So that's an area where people, you know, we say out of abundance of caution, depending on where you're practicing, where the seat of arbitration is or where the enforcement. The final point is that I've also seen very recently in a case we're involved in, opposing counsel who lost the case have made an application to the court that the award is forged and that the signature of the arbitrators are not the real signatures. So imagine, even this is a situation where people are making these sort of outrageous allegations in a way. So I think it's a little bit, we have some time before courts endorse that. And I think the faster the transition they make into a paperless society, the more receptive courts would be to digitally signed awards.
I don't know, Hafez, if you want to have a final comment on this. For what it's worth, I've asked the question actually a number of times now, two parties, when I am on a tribunal and we are issuing an award, whether they would prefer a wetting signature or electronic signature, and so far the answer has always been wetting.
I relate. It's also my experience, and the only thing I would add is you have this. The conversation plays out in similar terms when we come to blockchain-based awards and arbitration agreements.
Again, that will be a wonderful topic for the next debate. So mindful of time that we're now closing, just 1 minute left. I would like to use this 1 minute, first of all, to thank our speakers for their excellent, insightful, personal, provocative comments. But I would also like to thank the attendees for their excellent questions, very lively participation. I do apologize, I did not get to all of your questions. I've tried to catch as many as possible, sometimes summarizing them together. But again, thank you to all of you who have put in so many questions. And I should say it's also been quite encouraging to see the number of attendees being very stable throughout the seminar. Let me, a matter of housekeeping, remind you that this is a series of events that we do at the School of International Arbitration. And the next one is on the 10th of January, 2021, will be moderated by my colleague, Lucas Mistelis, and his guests and speakers will discuss the equally very interesting topic of confidentiality versus transparency. So do stay tuned if you're interested in that topic as well. And my colleague Nora Gallagher has reminded me that the School of International Arbitration survey that I mentioned earlier, the deadline for your answers is the 21st of December 2020. So you need to get going if you want to have your voice heard into the future of international arbitration in an adapting world. So with all of those remarks, I would like to close this event. And again, a big thanks to the speakers and the audience. Thank you.
And thank you, Maxi.
Thank you. Exactly. Thank you.
My pleasure.
Thank you, Maxi. Thanks to all. Bye-bye.
Bye-bye, everyone.